Hi there. My name is David Merrill, and I'm a bankruptcy attorney in West Palm Beach with the firm of Ozment Merrill. We're a bankruptcy firm that handles Chapter 7s, 11s, 13s, and 12s, and we're involved with most aspects of bankruptcy law in general. In addition, I also handle cases that are called adversary proceedings, which is a lawsuit in the bankruptcy court, and have had this practice, even though we're based in West Palm Beach and have an office in West Palm Beach. This practice is one that I enjoy throughout the state of Florida, and in fact, throughout the southeastern United States. While my partner Drake Ozment handles matters that involve consumer cases such as Chapter 7s and 13s, my practice is focused primarily on Chapter 11s, where you'll see sometimes it's individuals with complex business matters, but very often what we're dealing with, and more often, are businesses. And our firm has handled matters that, in the construction industry, real estate, manufacturing, healthcare, mostly privately held companies, but also publicly traded companies as well. There's a concept in bankruptcy that most people are not familiar with at all, and that is something known as an adversary proceeding. Now, those that have heard this term will call it an adversarial proceeding, and that's a little bit of a chuckler because that's not a correct term for it. But adversary proceeding is what we're talking about. And so folks listening to this are wondering, well, what on earth is that? Okay. The short answer is that an adversary proceeding is a lawsuit in the bankruptcy court. Now, what would get you sued in bankruptcy? Isn't that where I'm running to stop getting lawsuits coming after me and these types of problems? Well, yes. However, let's say in a Chapter 7 circumstance that you have decided to file bankruptcy, you did file bankruptcy, and as a part of your pre-bankruptcy planning, let's put that in quotes, you decided that it would be a great idea to run up the balance of your credit cards because you had some money left there apparently, and maybe you went off to Fiji and enjoyed, the nice sands of the beaches there, or you took off to Bora Bora, or maybe you like going to Alaska. But whatever you did, it was, something that was not necessary. You didn't need to do it, and it really ultimately is, and I can't mince words, it's bankruptcy fraud. The bottom line is that brand new 84-inch television set you bought, 2 months before you filed bankruptcy, that's not fair to your creditors. It's not something that's going to get discharged. And the procedure that a person called a trustee, and I'll explain who that is in a moment, but what a trustee does in that circumstance is they will file an adversary proceeding against you. And it could be for a raft of issues. It could simply be to revoke your, I say simply, it could be to revoke your discharge. It could be to say, we don't want a discharge entered. We don't, if a discharge was entered accidentally, we want it removed. That would be a disaster, because if you file a bankruptcy and don't get a discharge, you just lost the very thing you came to bankruptcy court to get. And wouldn't that be terrible? So if you're thinking about playing the fraud game, buying a bunch of stuff, or racking up your cards, don't do it, period. It's a bad idea. Think about it as the mom test. If you don't have a problem telling your mom, hey, this is what I did, you're probably okay. Unless mom's a crook, at which point forget what I said. The bottom line is keep it clean, do the right thing with respect to how that works. Now, moving on. There are other types of adversary proceedings. Let's say, for example, you are a tradesman and you provide carpentry services to a construction company. One of the worst things in the world that I see is a situation where a construction company, because they need to get particular jobs done, they'll pay you or pay your business for the work that it's done. And let's say they're running behind a little bit. Normally they were paying every 30 days, but now they're every 60, every 90, but they got you paid. And let's say that happened about 2 months before you filed bankruptcy. Well, you're going to get sued by, you heard it, a trustee who is going to be reaching out for what are called preference payments. Now, a preference payment is merely a situation where, by way of example, let's say you've got $4,000 in the bank. And as an individual, you owe $4,000 to American Express, MasterCard, Visa, and Mom. Now, everybody on the planet is going to pay Mom $4,000 and tell those other guys to go pound sand, right? Now, the deal with that is that the bankruptcy court says, look, there's nothing illegal about that, but we recognize that Mom is nothing more than another creditor. So they're going to go after mom and make her give that money back so that $1,000 each can be paid to each of those creditors and spread that money out. Now, in the context of the poor tradesmen, it's the same situation. They were paid for their services and work that they did, but the bankruptcy court will say, look, you have to give that money back, and you have to give it back because you were preferred to be paid over other creditors who were generally similarly situated, and so he spread that money amongst all the various creditors. That's about the worst thing in the world that the bankruptcy court and bankruptcy code does, so far as I'm aware, particularly because of the extraordinary hardships that it creates on the little guy. It's unfair, at least in appearance from that perspective, but it is the reality of that particular vagary of the code. If you've been sued, certainly come talk to us, because the reality is that there are defenses to these things. There are ways not to evade it, but there are ways certainly to be able to address it and to be able to keep as much money in your own pocket as possible. So definitely, if you've received a summons, come to us, talk to us, let's figure out what we can do to help. Let's talk about a summons. A lot of people get very caught up in the concept that, oh, I didn't receive a subpoena. No sheriff in a white shirt showed up and handed me anything. I didn't have a process server at my door. Well, don't be fooled. In bankruptcy court, they don't have to do that. They merely need mail it by first-class mail. So if you've received a lawsuit, you've been served. So be certain that you do the right thing within the time allotted and get in and see a lawyer and get your rights protected. Don't stand on your laurels thinking, well, I guess this is coming soon. It's already arrived and it's on your doorstep. This is David Merrill again, and I wanted to take a moment to thank you for taking the time to look through and watch the different information that we have for you on Chapter 11s and other chapters in bankruptcy. Drake and I at Ozment Merrill are happy to talk to you about any of these matters, and in fact, we offer an initial consultation that is free and would invite you to call us at 561-689-6789 at your convenience. We'll be happy to meet with you and talk about whatever the specific situation that you're facing is. Have a great day.